appeal of Patmalniece against Secretary of State who works in pensions.
Mr. Cox, before you begin, can I just discuss timetable?
My Lord.
Because you've presented us, rather to our surprise, I must say, with the proposition that you're going to speak for 6.5 hours,
My Lord,
which
I'm
we
afraid
find pretty disturbing. And if you add up all the bids for time, it's an hour and a half over the time we have available. So something has got to be done, and we would hope very much that you can address us for less than 6.5 hours, and you're asking for 2 hours reply, which we would have thought was excessive, although Mr. Lewis no doubt will say a lot of very interesting things in his submissions. So, please.
My Lord, I'm going to try to finish today,
Right.
but I may run over by about half an hour tomorrow morning.
Well, that seems a bit more sensible.
And hopefully that will leave a little more time for reply if it's necessary to respond. But I certainly anticipate that will leave both my friend Mr. Drabble with an hour and Mr. Lewis with the 5 hours that he's asked for.
And there's
so
one other point I
hours.
should mention, that we will have to rise at 3:30 tomorrow afternoon, and we'll see later on today how we accommodate that if necessary, but I hope that won't disturb the overall programme.
My Lord. Well, my Lord, I appear in this matter with my own friend Mr. Pickup and my own friend Mr. Lewis and Mr. Coppell appear for the respondent, and Mr. Drabble and Mr. Banner appear for the interveners. My Lord, what I propose to do is to follow the structure of the case in my oral submissions. Just want to mention a few of the salient facts.
You mean to say you're going to follow the structure of your case?
Going to follow the structure of my printed case.
Yes. I'm speaking entirely for myself, but I found it rather more difficult to digest than Mr. Lewis's, because Mr. Lewis had gone to some trouble at the beginning of his case to set out the various materials, the legislative materials that we need to look at, which you didn't do. So I hope you're going to introduce us to the subject in a way that we can really assimilate.
My Lord, I certainly tried to do that. I hadn't repeated the legislative materials that were set out in the case, in the Statement of Facts and Issues, and in my submission, ultimately, the legislative materials, the domestic ones and the European ones, fall within a relatively narrow compass, but the relevant ones. But I shall certainly expand on that.
Thank you.
So what I propose to do is to mention the facts and then to take your lordships to the domestic law provisions, to examine the way in which they work under domestic law, and then to turn to the central European law provision, which is Regulation 1408/71, and its enabling powers under which it's made, and address firstly the question as to whether or not there is direct discrimination as opposed to indirect discrimination, and then secondly, if there is indirect discrimination, whether or not the justification advanced by the respondent for that discrimination is one which is permissible to be advanced, because we say that it is not permissible. And then lastly, to deal with the point about the Irish citizens. My Lords, the facts are relatively straightforward. The appellant is a citizen of Latvia, and consequently from that country's accession to the European Union in 2005, a citizen of the European Union. She worked for some 40 years in Latvia, paying contributions into the Latvian social security scheme. She is now retired from that employment and receives a Latvian pension. She has lived in the United Kingdom for the last 10 years, and once Latvia joined the European Union, she made an application for state pension credit, which is a means-tested benefit paid only to pensioners aged 60 or above, and which supplements any contributory benefit that they may be receiving. The benefit was refused on the sole grounds that the appellant lacked a right to reside in the United Kingdom. It's not in dispute that she meets all of the other conditions, the domestic conditions of state pension credit, in particular that she's over 60, that she has a low income, that she's present in the United Kingdom, and that she is habitually resident in the United Kingdom.
She's never worked here.
She has never worked here.
Although she would be entitled to work here since Latvia joined the Union.
She has never worked here. She's looked for work, and that was in the evidence before the tribunal at first instance, but she hasn't found any work. But it's quite right that she has not looked here, that she has not found work here. And I will go on, I'll take your lordships to the broad definition of worker or employed person under European Union's social security legislation, which applies to a person like the appellant, and it's common ground that the appellant is an employed person for the purposes of that European Union legislation. So the sole ground of refusal of state pension credit was that the appellant lacks a right to reside in the UK. That is not to say that she is unlawfully present. The Court of Appeal accepted that she is lawfully present, but that she doesn't have an enforceable right to reside.
And it depends at what level you look at it, but on one view of the legislation, she is deemed not to be here. Is that right?
That's right, yes. I accept that the mechanism that the State Pension Credit Act uses to delimit entitlements to persons who do not have a right to reside. The mechanism the Secretary of State has used under the Act is to deem a person who does not have a right to reside to not be present in the United Kingdom. That is the domestic law mechanism. Yes. It is a different mechanism is used in the sister benefit, income support, which is the equivalent benefit paid to persons under 60. In the case of income support, the statutory mechanism used is to prescribe the needs of that person as nil. What we say is that the domestic mechanism by which a requirement to reside is introduced is irrelevant to the question of whether or not that requirement effects direct discrimination on nationality grounds.
I mean, as a matter of interest, was she unlawfully present when she was finally refused asylum, January 2004, until Latvia joined the EU in May 2004?
I don't know, my lord, because I don't know the detail of her original entry, but it's quite possible that she was. Yes, she certainly required she certainly required leave to enter and did not have it. Yes.
And I appreciate, I mean, it's extremely early to start asking questions like this, but, I mean, do you accept that if you're right on this case, I mean, she could be lawfully be expelled now?
We accept that it is possible that an expulsion decision could be taken, and that if an expulsion decision were taken, that she would then have a right of appeal to the first-tier tribunal and be able to argue there as to whether that step was a proportionate response, and the Secretary of State for the Home Department and on appeal the first-tier tribunal would have to give consideration to her particular facts. I cannot say that it would be impossible to uphold the decision to expel her, and certainly she would hope that she would win that appeal. But the important distinction between this set of rules and the other set of rules, the immigration or resident set of rules, is that this set of rules does not include any consideration of whether or not expulsion will be proportionate. Does not include an assessment of her length of residence, for example. So it may be that the Secretary of State would decide that expulsion wasn't proportionate, and it may be that if her appeal were upheld, he would give her some form of discretionary leave to remain with a consequent right to reside. But what the Secretary of State seeks to uphold is a set of rules that preclude entitlements to persons who do not currently possess a right to reside. And the Secretary of State will argue, and this is very much leaping ahead, that that is a more proportionate response than expulsion. What we say is that that brings over from one domain, the domain of immigration control and rights of residence, a discrimination on grounds of nationality into a different domain, that of social security, which we say is not permissible. My Lords, can I just take your Lordships then to the domestic legislation that is an issue? Lordships will find that in Volume 1 of the Bundle of Authorities. If we could start at Divider 3. What I want to show your Lordships, first of all, is why this case only concerns European Union citizens and not other foreign nationals. And at Divider 3, your Lordships will find that Section 115 of the Immigration and Asylum Act 1999, this came into force in the year 2000 and predates the introduction of the scheme with which your Lordships are now concerned. Your Lordships will see subsection 1, no person is entitled to income-based job seekers allowance under the Job Seekers Act 1995 or to state pension credit under the State Pension Credit Act 2002. And then follows a list of various benefits falling under the Social Security Contributions and Benefits Act 1992, and I just ask your Lordships to note that income support is listed there. And the exclusion applies, closing words of subsection 1, while he is a person to whom this section applies. And subsection 3 describes the class to whom subsection 1 or section 115 applies. Persons subject to immigration control unless he falls within such category or description or satisfies such conditions as may be prescribed. And then subsection 9, a person subject to immigration control means a person who is not a national of an EEA state. And pausing there, Lordships will appreciate that that's a reference to the European Economic Area, which encompasses all of the states that are in the European Union, at least under the domestic law definition. And then the subsequent requirements are that that person either requires leave to enter or remain in the United Kingdom but does not have it, or has leave to enter or remain which is subject to a condition that he does not have recourse to public funds, and then a couple of other less significant alternative conditions. So in 1999, Parliament had provided that as a general rule, non-European citizens will not be entitled to these means-tested benefits unless they have leave to remain in the United Kingdom, and that leave to remain is not subject to a public funds condition or a maintenance undertaking. So, were Latvia not to be a member state of the European Union, the appellant would fall at that hurdle, the section 115 hurdle. If I could ask your Lordships just to turn to the next divider, which is the State Pension Credit Act, or the initial sections of that Act. The Act follows a structure which is fairly typical of social security legislation, that it has broad entitlement conditions which are then defined by subordinate legislation. You see that the key conditions of entitlement, or the broad conditions of entitlement under subsection 1.2, are that a claimant is entitled to state pension credit if he is in Great Britain, he has attained the qualifying age, and he satisfies either the conditions in section 2.1 for a guarantee credit or the conditions in section 3 for a savings credit. Now, I can take your Lordships to sections 2 and 3. I don't propose to at the moment. They essentially impose a means test, slightly different means test, but again expressed in broad terms, the detail of which is provided for in subordinate legislation. Subsection 6 defines the qualifying age, and through a slightly convoluted phraseology provides that men and women are to be treated equally by reference to the pensionable age of a woman. There is no discrimination on grounds of age for the State Pension Credit Act. The State Pension Credit. Subsection 5 provides that regulations may make provisions for the purposes of this Act as to circumstances in which a person is to be treated as being or not being in Great Britain, or continuing a person's entitlement to state pension credit during periods of temporary absence from Great Britain. My Lords, that's the power that's been used to make the condition requiring a right to reside in the United Kingdom. If I could ask your Lordships just to go to...
As a matter of interest, Northern Ireland, of course, is excluded by the use of the phrase Great Britain.
It is.
Is there some separate legislation that applies in Northern Ireland?
Separate identical legislation relating to Northern Ireland. If your Lordships look over at Divider 5, there is the State Pension Credit Act Northern Ireland 2002.
Yes.
Section 1, I'm afraid it doesn't have that in the heading, but your Lordships will see that in the very top of the
Yes, so it's really the same thing.
It is. Certainly, I'm not aware of any distinction, and my understanding is that the policy intention is that it should work in identical terms. Mm-hmm. And there are reciprocal provisions between Great Britain and Northern Ireland, which provide for the scheme to be seamless. At least that's my understanding. But your Lordships will see subsection 1(5) of the Northern Ireland Act has the same enabling power.
Thank you.
The power has been used to make the amendments to the state pension credit regulations, and those appear, or the relevant regulation appears at divider 9. As originally drafted, the paragraph 1 did not include the phrase subject to paragraph 2. Paragraph 2 is inserted, as we shall see, by amending regulations later on. The effect of paragraph 1 is generally to impose a requirement that a person be habitually resident in the United Kingdom, the Channel Islands, the Isle of Man, or the Republic of Ireland. And it does that by providing that a person is to be treated as not in Great Britain if he is not habitually resident in one of those places. Paragraph 1 then sets out a series of exceptions to that deeming provision, the deeming provision that a person who is not habitually resident is not to be treated as in Great Britain, and provides A for an exception for persons who are workers for the purposes of Council Regulation 1612/68 or various other EC legislation. Now, those are different provisions from the Social Security Coordination Regulation, which we will be looking at. And under each of those provisions, a person so described has a right to reside in the United Kingdom. So this is an exemption for those classes of people who also have a right to reside from the requirement to be actually habitually resident in the United Kingdom. But as I've mentioned, it's not in dispute that the appellant is somebody who is habitually resident in the United Kingdom within the meaning of paragraph 1.
But not within 1A.
She's not within 1A, no, but she doesn't need to be within...
No, I've not.
No, absolutely. It's not asserted by us that she falls within 1A.
She's not a worker for 1A purposes.
No. Paragraph 2 is the new provision that was inserted by the Habitual Resident Amendment Regulations. I'll take your Lordships to those in a moment just to see them. But your Lordships will see, for the purposes of treating a person as not in Great Britain in paragraph 1, no person shall be treated as habitually resident in the United Kingdom, the Channel Islands, the Isle of Man, or the Republic of Ireland, if he does not have a right to reside in one of those places. So the mechanism used in the state pension credit scheme to require all applicants, all claimants, to have a right to reside is that those who do not have a right to reside may not be treated as habitually resident in the United Kingdom and therefore are treated as not in Great Britain under the State Pension Credit Act. Now, there's no requirement for the mechanism, for that particular mechanism to have been used to make this rule. As I've mentioned, a different mechanism is used to make the identical provision in the income support rules. And we can see the breadth of the introduction of the right to reside requirements in the Habitual Residence Amendment Regulations, which are at the previous divider, divider 8. Lordships will see that these regulations came into force on the 1st of May 2004. And turning over the page, your Lordships will see that the regulations amend a variety of different provisions. So Regulation 2 amends both the council tax benefit regulations and the housing benefit regulations, where different mechanisms are used. For example, in Regulation 7A of the housing benefit regulations, the mechanism used is that a person is deemed not to have a liability to pay rent. The income support regulations are also amended, but again, by exactly the same provision. So we see Regulation 3C inserts a new 3 large G, which reads in identical terms, or in materially identical terms, to that we've looked at for state pension credit. Similar provision is made for job seekers allowance. Your Lordships will see the provision dealing with state pension credit at Regulation 5, and then at Regulation 6, various transitional arrangements and savings. Now, subject to those transitional arrangements and savings, from the 1st of May 2004, any European Union citizen claimant of these benefits must have a right to reside in the United Kingdom or Channel Islands, the Isle of Man or Ireland, in order to be entitled to them. And there's no dispute about that. Now, this appeal is concerned only with state pension credit, and different considerations will apply to different benefits. The issue in this appeal is whether or not a universal requirement for European Union citizens to have a right to reside in the United Kingdom is one that is precluded by the prohibition on discrimination in Regulation 1408/71. But before we look at that, just to note certain matters that were recorded in the Statements of Facts and Issues and are common ground. It's common ground that a British citizen, I could ask your Lordship just to look at that, it's in, of course, the core volume, page 11.
So we've got a list of undisputed matters, which is very helpful. So which number in this list?
And in particular, 29.
29, yeah.
All UK nationals, we use that terminology because that fits with the language of the European Union, but of course in domestic legislation that's British citizens. All UK nationals have a right to reside in the UK because by virtue of their nationality, they have the right of abode in the United Kingdom under Section 2.1. And all Irish nationals have a right to reside in the Republic of Ireland by virtue of their nationality. Now that's significant because the Regulation 2.2 places on the same footing the right to reside in Ireland as the right to reside in the United Kingdom. So it's common ground that persons who are British citizens or Irish citizens, by virtue of their nationality, pass this new requirement. It imposes no additional burden, in our submission, it therefore imposes no additional burden on them. Can I ask your Lordship then to look at the provisions of community law under which the Regulation 1408/71 is made before we turn to that regulation. And that divider 10 in volume 1 of the authorities we'll see there's a table of equivalencies to the relevant articles, and then over the page where the text of the articles is set out. If your Lordships will look first at Article 12, which is the general prohibition on discrimination.
So we're looking at post-Amsterdam.
Well, the language that we've used is indeed in the central column, yes. Post-Amsterdam, pre-Lisbon.
And that's because of the timing of the decision we're looking at, is it? Yes,
my Lord, it is. It's also which also coincides with the timing of when the regulations were made. So there's no material difference between 1st of May, when they were made, 1st of May 2004, and when the material period at issue here, as far as the articles of the treaty are concerned. So the first relevant article is Article 12. Within the scope of application of this treaty, and without prejudice to any special provisions contained therein, any discrimination on grounds of nationality shall be prohibited. The Council, acting in accordance with the procedure referred to in Article 251, may adopt rules designed to prohibit such discrimination. Now, Article 12, Article 6 as was, is one of the enabling powers for the Regulation 1408/71. And if your Lordships will just turn over 2 leaves to the page that has Article 38 at the top. Your Lordships will see a third of the way down. Title 3, Free Movement of Persons, Services and Capital. Chapter 1, Workers. Article 39. Article 39.1, freedom of movement for workers shall be secured within the community. And Article 42 over the page at the bottom Council shall, acting in accordance with the procedure referred to in Article 251, adopt such measures in the field of social security as are necessary to provide freedom of movement for workers. Just pausing there, I ask your Lordships to note the reference to social security, which will say that's in distinction to social assistance. It continues, to this end, it shall make arrangements to secure for migrant workers and their dependents, and over the page, aggregation for the purposes of acquiring and retaining the right to benefit and of calculating the amount of benefit of all periods taken into account under the laws of the several countries, and payment of benefits to persons resident in the territories of member states. And then again the provision, the Council shall act unanimously throughout, that should be through, the procedure referred to in Article 251. Then just turning over the page to see how the treaty refers to regulations, because we are dealing here with a regulation and not a directive. In Article 249, the second of those paragraphs, a regulation shall have general application, it shall be binding in its entirety and directly applicable in all member states. A directive shall be binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authorities the choice of form and methods. So those are the two distinct mechanisms by which community law is made. And as we shall see, the regulation in question, of course, has no implementing provisions in national law. It is directly and immediately effective without any intervening legal mechanism.
Yes. Do we need to bear in mind Article 18? That's part of the history, is it?
My Lord, it is, yes. Your Lordship's right. What the Secretary of State will say is that because Article 18 does not confer upon the appellant a right to reside in the United Kingdom, that in some way conditions the operation of the provisions made under Article 42. At least that's my understanding of how it's put. That's certainly how the Court of Appeal saw it. And my submission will be that their Article 18 and its operation does not condition the prohibition on discrimination in Article 42, or made under Article 42.
But I mean, you're not a worker for 42 purposes.
Well, no, we say that we are, absolutely.
I see.
No, we say that we are under 42. Yes.
And that's, you'll come to this, so that's because she was a worker before?
That's because the definition in 1408/71 applies to persons who have been employed and have retired from that employment.
Presumably, what's happened under Article 42 is why she's entitled to have her Latvian pension paid here.
It is why
That's
she's
the
entitled
point
to
of
have
it,
that
isn't
pension
it?
paid here. Yes.
Yep. You can go and live wherever you like in the Union and you can still get your contributory benefits paid there.
Yes. You can still get your classic social security benefits paid there, in fact. And it's accepted that that under those measures there are restrictions on the geographical scope of where other benefits may be paid. But it will be our submission that there is no permission to discriminate on grounds of nationality in respect to those benefits. Can I just take your Lordships then to Regulation 1408/71, which is in material form at Divider 20. We have it in, sorry, not at Divider 20, I apologise. At Divider 16. We have it in various other forms if your Lordships need to see it, and if your Lordships would wish it, we have a full copy of the version as it appears, but it's quite lengthy, and so we haven't included all of it in the bundle of authorities. And we also have it in French. If your Lordships want to see it. Some of the cases
Yes.
are better understood if one looks at the French text, but it may not be necessary to do that. So if your Lordships would just turn to page 8 of the text, and that's at the top above the tram line in the right-hand corner of the page.
Eight.
Firstly, persons covered under Article 2. This regulation shall apply to employed or self-employed persons and to students who are or have been subject to the legislation of one or more member states and who are nationals of one of the member states. And one can pause there. That is the personal scope of the regulation as it applies to the appellant. and it is common ground that by virtue, that because of the contributions that she paid into the Latvian scheme, she is an employed person. Now, in older versions of this regulation, the term worker was used. The current version uses the term employed person.
You get the definition in Article 1, isn't it?
The definition is in Article 1, my lord. Yes, that's quite right. Which is page 4, and it covers a number of different categories, but we would fall under A, Roman 1, any person who is insured compulsorily or on an optional continued basis for one or more of the contingencies covered by the branches of a social scheme for employed or self-employed persons. And the nature of insured means that it continues to apply to a person who has paid in contributions. And as one might expect, a key function of the regulation is to address the situation of community nationals who have retired from work and now find themselves living in or have moved to a different member state from that in which they were employed. And as I say, there's no dispute that the appellant is covered by Article 2. But just to illustrate to your lordships the breadth of scope of Article 2 and the way in which it operates differently from rights to reside, I ask just your lordships to look briefly at the case of Kaczmarek, which is at volume 2 of the authorities, and at divider 33. Now, this is a case that was argued before the Court of Appeal, not under this regulation, but under the wider or narrower, depending upon which aspects of it one was concerned with, provision of Article 12 of the treaty. And I'll be addressing the distinction between this line of cases and the case at hand a little later. But I want your lordships just to see that the facts of this case are someone who didn't have a right to reside in the United Kingdom. See at H3, she was a Polish national who'd come to the United Kingdom as a student in April 2002, so before Poland had acceded to the community. She later worked in a nursing home from June 2003 until July 2004. She was on maternity leave from August 2004 until February 2005. Although it had been her intention to return to work, she did not do so as her child was unwell. She could not afford a childminder. In May 2005, so pausing there, that's when Poland joined the community, she applied unsuccessfully for income support. Sorry, I'm so sorry, no it isn't. It's a year after Poland joined the community, I'm so sorry. So she'd worked after Poland had joined the community. She applied unsuccessfully for income support. She regained employment in October 2006. It was common ground that she was not entitled to income support under domestic legislation, which essentially restricted entitlement to EEA nationals who were economically or educationally active or otherwise self-sufficient. Kay argued that entitlement to income support arose under Articles 2 and 18 EC. Now, it would be my submission that Ms Kaczmarek, having paid contributions on her work in a nursing home in the United Kingdom, was clearly also a person who was an employed person under 1408/71, though clearly it was the determination of the Court of Appeal that she lacked a right to reside. So the difference between the class of employed persons under 1408/71 and those who have a right to reside under the residence provisions is quite significant.
I'm sorry, what is this case now authority for?
I don't cite it as authority. What I cite it for is a parallel example of the breadth of the class that lies between persons who have the right to reside under European legislation and persons who, it's an example of those persons who have the status of employed person under Regulation 1408/71, yet lack a right to reside under European Union.
So she was in exactly the same case as your client?
Yes, we would say.
But she lost?
She lost because she wasn't relying on 1408/71.
She should have won if she'd had done. She missed a trick, is that it? I mean, I just want to know where we are.
Yes.
I see.
Could she have taken the point in that case, or it's just oversight, was it?
I don't know why she didn't take it. She didn't take it.
But she would have won if she had. I mean, that's your simple proposition.
She would have won on the argument that I'm presenting, yes.
Yes, I mean, it's no doubt disputed, but that's Yes, if you're right.
If I'm right, she wins too.
So do we have to look at who was representing her?
Given where your lordships are sitting, no, because your lordships aren't bound by Kaczmarek and wouldn't be bound by any inadequacies of, or anything arising from the way in which her case was presented.
Doesn't tell you anything.
Doesn't tell you.
What?
We don't know who is appearing.
Very discreet.
We know
Miss
that
Leven?
it's the same Social Security Commissioner as we have in this case, is
It
it
is,
not?
yes.
Is it Miss Leven? I mean,
It is Miss Leven
Yes,
who
it's
was...
mentioned in paragraph 1.
Well, Miss
Yeah.
Leven is mentioned in paragraph 1.
Miss Leven was,
Has been wisely
Miss
abandoned.
Leven was appearing for Mr Kaczmarek.
Can I end the mystery, actually? I drafted the skeleton argument to the Catholic. The representation was by Miss Leven. I drafted a petition to this court, not to this court, to the House of Lords, which was dismissed. And
Was I party to dismissing it?
yes,
Thought I.
and I should be saying that was wrong.
Of course you will. I've worked out what your position is, Mr Drabble.
sorry, this is one where the House of Lords refused leave to appeal.
Yes, absolutely. We deal with it in our short case.
Well,
but
I
there's,
thought you
yeah,
did,
yeah.
yeah.
But I cite it as an example of a person who also falls within Regulation 140871, and albeit having worked here, both before accession and after accession, does not have a right to reside here, but clearly would be an employed person within the material scope of Article 2.
Yes. So we put that away for the time being.
Thank you. Turning to the Article 3, which I'll return to in more detail, but just to note to your lordships while we're going through 140871. So Article 3 provides, subject to the special provisions of this regulation, persons to whom this regulation applies shall be subject to the same obligations and enjoy the same benefits under the legislation of any member state as the nationals of the state. And an example of an exception to that rule can be seen in Article 3.2. The provisions of paragraph 1 shall apply to the right to elect members of the organs of social security institutions or to participate in their nomination, but shall not affect the legislative provisions of any member state relating to eligibility or methods of nomination of persons concerned to those organs. In other words, there's a right of equal treatment for voters, but not to stand to be elected to the organs.
But not for what?
But not to stand to be elected to the social security bodies.
So it distinguishes between voters and candidates. Would that be
It
right?
distinguishes between electors and candidates, yes. That's an example of an express exception to the prohibition on discrimination. Now we shall say there's no relevant exception in Article 3.1 for persons who lack a right to reside or in respect of the benefit at issue here. And certainly no exception has been identified in the text of Regulation 140871 in any of the proceedings to date. Article 4 deals with the material scope of Regulation 140871. Regulation shall apply to all legislation concerning the following branches of social security. It then lists a series of matters which are sometimes referred to as risks: sickness and maternity, invalidity, old age, being a survivor, accidents at work and occupational diseases, death, unemployment and family benefits. As we shall see, the case law of the Court of Justice is that a benefit which gives rise to legal entitlement, not dependent on discretion, and which it concerns one of those branches, is a social security benefit under both Regulation 140871 and the enabling provision, Article 42 of the treaty. So we see in paragraph 2, this regulation shall apply to all general and special social security schemes, whether contributory or non-contributory, and to schemes concerning the liability of an employer or ship owner, in respect of the benefits referred to in paragraph 1. Now, paragraph 2A and 2B were inserted by amendment from the 5th of May 2005.
Sorry, just as
So-
regards Article 4, so the notion of social assistance being different from social security is not found in Article 4, is that right?
It is, yes. Article 4.4,
Right.
this regulation shall not apply to social and medical assistance, to benefit schemes for victims of war or its consequences. So on the next page,
Oh, yes.
just above Article 5.
Thank you.
And I'll take your lordships to the case law that explains that distinction between social security and social assistance. But it's our case that social assistance and coordination of it and equal treatment in respect of it lies outside 140871, as it does outside the enabling power of Article 42 of the treaty.
Well, just bringing it to life, give me an instance of social assistance as opposed to social security.
Housing benefit, because housing benefit is not related to any of the risks identified in 4.1. Housing benefit is paid to everybody who has a low income and rents, whether they are young, old, sick, well, with children, without children, invalid, not invalid.
So I'm just getting the overall shape of the case. I mean, they can properly withhold housing benefit from your client.
Housing benefit is not a benefit that falls under Regulation 140871.
So the answer to my question is yes?
The answer is that 140871 doesn't preclude that, yes. And I'm only relying on 140871. So yes, the Secretary of State could, without infringing the rules in 140871, structure his social assistance scheme, or however he wishes, because that lies entirely outside the scope of 140871.
But are you defining social assistance? You're going to take us to case law, aren't you? Because obviously in the olden days, one would have thought of drawing a distinction between social security benefits and things like income support, which is the successor to national assistance. And that's the sort of distinction one was drawing. You're saying it only excludes things that don't have anything to do with the listed emergencies in
I'm saying, well, it's common ground.
Article 4.1.
So sorry. It's common ground that both state pension credit and income support fall within Regulation 140871. My case is that 140871 prohibits discrimination in respect of the benefits that it applies to.
And can you just, for my information, identify within Article 4.1 which of the various things listed there we're concerned with? Does it fall within with any of these?
State pension credit relates to the branch of social security that is old age benefits.
Yes.
But it is subject to special provision in Article 4.2a.
Yes.
And I'll just take your lordships to that. Now, Article 4.2a, as we shall see, is the provision that deals with what have been called hybrid benefits. And we can see that in the opening words. This article shall apply to special non-contributory cash benefits which are provided under legislation which, because of its personal scope, objectives and or conditions for entitlement, has characteristics both of the social security legislation referred to in paragraph 1 and of social assistance. So we shall say that Article 2A spells out the application of 140871 to that class of social security, which also has characteristics of social assistance. But it does not alter the effect of Article 4.4, which excludes, as it were, pure social assistance. Now, the reason that state pension credit falls under 2A is because it falls under the definition of special non-contributory cash benefit in 2A, which we see means benefits A, which are intended to provide either, and then Roman 1, supplementary, substitute or ancillary cover against the risks covered by the branches of social security referred to in paragraph 1. And pausing there, state pension credit relates to old age. And which guarantee the persons concerned a minimum subsistence income having regard to the economic and social situation in the member states concerned. So state pension credit meets Roman 1 of paragraph A. And there are two further requirements, B and C. B requires that the benefit is financed exclusively from compulsory taxation intended to cover general public expenditure. And C, that it must be listed in Annex 2A to the regulation. And the text of Annex 2A appears towards the end of this divider, if your Lordships will just look at the penultimate page, at the bottom, this is page 81, your Lordships will see point Y of Annex 2A, the United Kingdom, and the benefits listed there: state pension credit, income-based allowance for job seekers, income support, disability living allowance, and over the page, attendance allowance and carers allowance. Now, in fact, though it doesn't have any bearing on this case, for completeness, your Lordships may wish to note that judgment of the Court of Justice has took the care component of disability living allowance and attendance allowance and carers allowance out of that provision on the basis that they were not true special non-contributory cash benefits. But there's no dispute that state pension credit falls under, and properly falls under paragraph 2A.
Yes, that's paragraph 24 of the Statement of Facts.
My lord.
Yeah. Thank you.
So that's Article 4. Can I just take your Lordships to see how Article 4 came to be in that form, by looking at some of the cases in which the Court of Justice has defined the distinction between social security and social assistance. Can I just ask your Lordships to look first at the case of Frilly, which is in Divider 5.
Well, just before you do, I'm sorry, I'm just trying to get the overall shape
Yes,
of this. I mean, what is the argument you're meeting here? I mean, what is the difference between you on this point?
Well, my lords, the Secretary of State doesn't dispute that Article 3 prohibits all discrimination in respect to state pension credit as regards my client, the appellant, because she is a person who falls under Article 2.
So?
Well, my lord, it may be that these things will be better dealt with by my learned friend, but what he seems to be arguing is that because state pension credit is a special non-contributory cash benefit, that therefore in some way it is permissible to discriminate against those who do not have a right to reside. He says that singling out European Union citizens who do not have a right to reside, that is non-British, non-Irish citizens who do not have a right to reside, is not discrimination under Article 3 because it relates to a special non-contributory cash benefit. And the reason that he says that is because he says that there is a principle of European Union law that one can confine payment of social assistance benefits, and he says this is one, that one can confine payment of social assistance benefits to one's own nationals.
But I thought what he was saying was much simpler. This is not direct discrimination, it's indirect discrimination, and it's justified.
Well, my lady, he says that it is not, that it is indirect discrimination, and I'm about to take issue with that, because I say that it is...
Of course you're going to take issue with it.
My lady, the reason why he says it's justified is because he says that there is a principle that one can discriminate against people who aren't British or Irish.
But he only gets into that argument if he's right on the first point.
My lord, yes, that's right. But I say that the answer is very simple. I say it is direct discrimination, as was found at first instance, and direct discrimination can't be justified. In other words, 140871 doesn't have any exceptions for people who lack a right to reside. It doesn't have any special rule about discriminating against them in respect of social security benefits that have characteristics of social assistance, and that's the end of it. I will, of course, try to address the arguments as to whether there is a general principle,
Yeah.
but I say that one doesn't need to reach those unless one can find in Regulation 140871 a exception or rule permitting discrimination on nationality grounds, and I say there isn't one. But I take your Lordships to it in order that your Lordships can see the structure of the regulation and that it clearly encompasses, as social security and not as social assistance, benefits like this one. Can I just ask your Lordship then to turn to Frilly at...
You say volume 5?
Volume 5, divider 60, tab 60.
And you're referring us to this because we need the assistance of this case, am I right to understand?
I'm referring your Lordships to this because it shows it is the first case dealing with benefits that are social security but have characteristics of social assistance. And I want to show it to your Lordships to show the Court of Appeal was wrong to think that the amendment to Regulation 140871 somehow added these benefits in.
It's very past history. I mean, is it really necessary to go back as far as this to understand?
I don't necessarily need to go to it. I simply wanted to show to your lordship, I don't know if it's in dispute, that for 20 years before these amendments were made, benefits like state pension credit had fallen under Regulation 1408/71.
And the point is that we now look at 2A of Article 4, don't we? And we get
You do, my lord,
get the
absolutely, I accept
instruction
that.
there.
I don't need to go to it, unless it's to be said that the Court of Appeal was right to think that this was a new extension. But I haven't seen that in my own friend's case. We certainly said that the Court of Appeal got it wrong, and that aspect of their decision doesn't seem to be defended. So I can pass on. In terms, though, of the distinction between social security and social assistance benefits, can I just show your lordships the case of Herx, which is also at volume 6, tab 64. I'm so sorry, still in volume 5, tab 64. I apologise. Just to give your lordships, show your lordships a benefit that falls outside Regulation 1408/71. Just ask your lordships to...
Right, and just for the proposition for which you're citing this,
I'm citing it as an example to show your lordships the test for social security and the test for social assistance.
this is only a quarter of a century old, so this is relevant.
They're all relevant. They're relevant, my lord.
Necessary.
My lord, I don't need to cite it to you. If it's simply to show your lordships the text from which the distinction comes between social security and social assistance.
So do we have a nice crisp statement of the text?
Well, there was one in Frilly.
Well,
it's been
this'll
recited. You have a nice crisp statement in the appellant's case. If your lordships want to look there, it's at paragraph 37. I don't think it's in dispute. Page 10.
You've already actually made these points, I think, haven't you? What we see in paragraph 37.
My lord, I've tried to, yes.
And I'm just looking to see on the list of undisputed matters. Are we still in the area of what is not in dispute?
Well, my lord, it's hard to say whether or not it's in dispute.
This is 37 of your printed case.
But if I could just take your lordships to paragraph 37 of my printed case at page 10, and then I'll move on to the question of whether or not there is direct discrimination.
Yes.
So the test for a social security benefit, as I say there, is that it confers upon beneficiaries a legally defined position, giving a right to benefit rather than requiring an individual consideration of the case, and it covers one of the risks contained in Article 4.1. And that's why state pension credit is a social security benefit.
So that would be a distinction between entitlement and discretion.
Yes. So discretionary social fund payment, even if it was addressed at old age, would not be social security because it would depend upon a discretionary judgment of the officer responsible.
Like?
A discretionary social fund payment, so a crisis loan, for example. Even if one can find crisis loans to incapable people or elderly people, so long as they required an individual exercise of discretion, they would not be a social security benefit. A housing benefit is while it confers upon beneficiaries a legally defined position, it does not cover one of the risks contained in Article 4.1, and so falls for that reason. I'll just take your lordships then to the case law under Article 3, and to show your lordships why we say this is direct discrimination, not indirect discrimination. Ask your lordships to look at volume 4. Judgment in Borovitz, tab 47. I take your lordships to this for the propositions on what is the settled case law on the approach to discrimination under Regulation 1408/71. If your lordships would turn to page 7314, just to see the way that the issue arose. This concerned a German benefit rule which differentiated in its payments threshold for persons outside Germany from persons inside Germany. And at paragraph 20, the Commission had questioned whether or not there was even indirect discrimination. Paragraph 20, as regards possible indirect discrimination, the Commission points out that insofar as the German legislation provides for a higher threshold amount in respect to payments abroad, recipients of pensions who are resident abroad are placed at a disadvantage. The Commission, however, questions whether that disadvantage particularly affects German nationals or nationals of other member states, submits that there is no doubt that nationals of other member states are also concerned, namely all those who at the end of their working life in Germany return to their country of origin, and nationals of other member states who are in receipt of a German pension in their capacity as former frontier workers. Consequently, the existence of indirect discrimination is, according to the Commission, doubtful. Now, the Court replies to that in paragraph 23. Must be borne in mind that the object of Article 3.1 of Regulation 1408/71 is to ensure, in accordance with Article 48 of the Treaty, equal treatment in matters of social security, without distinction based on nationality, for the persons to whom that regulation applies, by abolishing all discrimination in that regard deriving from the national legislation of the member states. And then the formulation that appears in many cases, it is settled case law that the principle of equal treatment, as laid down in that article, prohibits not only overt discrimination based on the nationality of the beneficiaries of social security schemes, but also all covert forms of discrimination which, through the application of other distinguishing criteria, lead in fact to the same result.
I'm sure I understand what that really means. I mean, we use the expression direct discrimination and indirect. Is this really telling us that anything that falls within what that paragraph is talking about is to be treated as direct discrimination?
No, my Lord. In my submission, the case law of the Court of Justice fits with our own case law on direct and indirect, albeit it speaks of it in slightly different terms. Mm-hmm. And the Court is here referring to both. The first class, direct, is often described as overt, and that is where the discrimination is based on the nationality of the beneficiary. The second class, which we refer to as indirect, but which the Court has often called covert, is where the discrimination is not based on the nationality, it is based on other distinguishing criteria, but they lead in fact to the same result.
But that's not the same as the concept of indirect discrimination as we understand it, because we're looking for disparate impact, whereas this is talking about leading to the same result.
Yeah. Well, my Lord, my Lady, in my submission, where it says in the same, lead in fact to the same result, that means leads to a discriminatory consequence.
Not the same result in every case.
No. So the results being referred to...
But as I say, indirect discrimination is at one remove further back, because what it's doing is, by applying the particular criterion, it is affecting the protected characteristic differentially.
Yes.
Which is not what this is saying. I'm just trying to get my head around these different concepts.
My Lady, in my submission, it is trying to say that. So as we shall see, if we turn over and see, because in this case what the Court does is expand upon that second part. But what I want your Lordships to bear in mind is that it is only indirect if it is not direct. If it is in fact if it is based on the nationality of the persons concerned, as opposed to based on other distinguishing criteria, it is direct discrimination. It is overt discrimination.
And that's your proposition.
And my proposition is that a requirement that a person has a right to reside, which as a matter of law distinguishes between those who possess it by virtue of nationality and those who must complete some additional task in order to possess it, such as working here. That is a distinction that is based on the nationality of the persons concerned. It is not the application of other distinguishing criteria. Now, the explanation of the second part is dealt with over the page. Accordingly, conditions imposed by national law must be regarded as indirectly discriminatory, where, although applicable irrespective of nationality, and in my submission that backs up what I've just said, a requirement of a right to reside which certain people meet by virtue of nationality is not applicable irrespective of nationality. The Court continues they affect essentially migrant workers, or where the great majority of those are affected are migrant workers, as well as conditions which are applicable without distinction but can more easily be satisfied by national workers than migrant workers, or where there is a risk that they may operate to the particular detriment of migrant workers.
Well, that's a classic description of indirect discrimination.
My lady, that's what the court is, in my submission, that's what the court is summarising at 24, when they talk about covert forms of discrimination, which through the application of other distinguishing criteria lead in fact to discrimination on nationality grounds.
That's because they say accordingly.
Well,
If they didn't say accordingly, you would say they've got three different sorts of discrimination here.
my lord, my lady, I'm not sure I would, because I'm not sure conceptually there would be three different types of discrimination. In my submission conceptually, and I just make this submission now, there are only two types of discrimination. There are discrimination which is based on a condition of nationality, which is incapable of justification because it is based on condition of nationality. And then there is discrimination which is based on something that has nothing to do with nationality. Here, for example, where one is living, inside Germany, outside Germany. And that can be justified, and we see that at 26. It is otherwise only if those provisions are justified by objective considerations independent of the nationality of the workers concerned, and if they are proportionate to the legitimate aim pursued by the national law.
Presumably that phrase, overt discrimination based on nationality, takes its instruction from Article 12. Is that what it's doing?
Article 12 is the overarching provision on discrimination, yes, absolutely. And the court uses identical terminology to describe the prohibition on discrimination in Article 12, yes. But in my submission, Article 3, the personal scope of Article 3 is not limited to whatever the personal scope of Article 12 is, as we shall see. So what is required is justification by objective considerations independent of the nationality of the workers concerned. And my submission, of course, is that a requirement to have a right to reside, which is satisfied by virtue of the nationality of the United Kingdom and Irish persons concerned, and whose consideration is to exclude from entitlement other European Union nationals than British and Irish citizens, is not independent of the nationality of those persons. It is calculated to exclude, by reference, the nationality of those persons. It is directed to non-British, non-Irish citizens. And so my submission is that the court does not reach the question as to whether or not there's the measure is proportionate to the legitimate aim, because the aim pursued is not independent of the nationality of the workers concerned. And just to see the way in which the court deals with the issue at hand, the court finds it to be unjustified indirect discrimination. And we see that in 27 and 28. It is clear from that body of case law that unless it is objectively justified and proportionate to its aim, a provision of national law must be regarded as indirectly discriminatory if it is intrinsically liable to affect the nationals of other member states more than nationals of the state whose legislation is in point, and if there is a consequent risk that it will place the former at a particular disadvantage. 28. That is true of a provision which, like that at issue in the main proceedings, fixes a higher threshold amount in respect of payments made abroad than that applicable to domestic payments. It operates in practice like a residence requirement, which is more easily satisfied by national beneficiaries than by beneficiaries from other member states.
Was Mr. Borowitz a German national?
I don't think Mr. Borowitz was. No, I'm not sure if we're told his nationality.
It doesn't seem to say.
No.
If he was a German national, he was trying to rely on an alleged on indirect discrimination in order to get a benefit because he was a German national living in the Netherlands.
Yes, indeed. I don't think one sees...
It's fairly amazing that we're not told his nationality.
Certainly his name conjures up the possibility that he might not be German, but I don't think that either the Advocate General's opinion or the judgment tells us his nationality.
Well, he seems to have taken quite a lot of proceedings in places like Munster and so on, in Germany.
Yes. And just to finish that off, paragraph 29 over the page, such provision is especially liable to affect nationals of other member states since the proportion of such nationals is inherently likely to be higher amongst recipients of pension payments outside Germany than amongst those in receipt of pension payments within that state. And then it then looks at the possibility of justification essentially on the grounds of higher expenses, administered by those abroad, and rejects that and concludes that in essence the differentiation between those living inside and outside Germany is not justified.
According to the report says the Commission points out that it's impossible to ascertain whether Mr. Borovitz satisfies the condition of having community national status. Paragraph 23, page 7299.
Yes. Well, of course, the Court of Justice's ruling doesn't dispose of the matter, and it may be that when it was returned, Mr. Borovitz didn't get paid his pension if someone showed that he didn't fall within the personal scope of Regulation 1408/71. But what the Court is saying is that for persons who fall within the personal scope of Regulation 1408/71, such a provision is precluded. Now, can I ask your Lordships to turn to the judgment in Herx, which is in volume 6, tab 64.
564.
5.
I'm so sorry. Yes, it is. I'm so sorry. I don't know how that happened. 5.
And what are we going to get from that?
We're going to get from that an confirmation of the distinction between direct and indirect. Since the language used there might not be that clear, I want to take your Lordships to a case where both the Court and the Advocate General show us the difference. Now,
We're going to an earlier case.
an earlier case, yes, my Lord. The Court first of all looked, and this is at page 650 at paragraph 9, at whether or not the benefit fell within Regulation 1408/71. And it concluded, at the foot of page 651 and paragraph 14, that an allowance like the one at issue being a general social benefit cannot be classified under one of the branches of social security listed in Article 4.1 of Regulation 1408/71, and therefore does not constitute a social security benefit within the specific meaning of that regulation. This benefit is the Belgian Minimex, and we'll see that it reappears in the case of Trojani, upon which my own friend places heavy reliance. So the Court was there holding that the Minimex does not fall within the scope of Regulation 1408/71. So it then looked at whether or not Mr. Herx could nevertheless rely upon a different prohibition on nationality. We see that over the page 652 at question 3, halfway down. And in particular at paragraph 19, where the text of Article 7 of Regulation 1612 of 68 is set out. We see that at paragraph 2 of that article, he shall enjoy the same social and tax advantages as national workers. And the Court then explains how it has dealt with the material scope and the personal scope of that provision, and concludes at 22, it follows from all the foregoing considerations that a benefit guaranteeing a minimum means of subsistence constitutes a social advantage within the meaning of Regulation 1612/68, which may not be denied to a migrant worker who is a national of another member state and is resident within the territory of that state paying the benefit. So the Court, having found that the benefit fell outside the material scope of 1408/71, located it within the material scope of a different equivalent provision in 1612/68.
But is that going to help us or confuse us?
Well, I hope it won't. I hope it will help you, because it's the Court's treatment of the issue of discrimination that matters.
Right.
But in my submission, it's the same test that's applied, but with a different personal and material scope. And we see that the Court explains at 24, the residence requirement in that case, and I'll show you Lordships that in a moment, The residence requirement is an additional condition imposed on workers who are nationals of a member state but not national workers. It therefore constitutes a clear case of discrimination on the basis of nationality of workers.
You're talking about
Can I just show you, Lordship,
overt.
at 649, at paragraph 5.
I beg your pardon? Paragraph 5?
Page 649.
Yes.
We see that Mrs. Hooks had been refused the Minimex because of Section 1 of the Royal Decree of the 8th of January 1976, which provides that nationals of member states of the European Economic Community are entitled to the Minimex, provided inter alia that they, quote, have actually resided in Belgium for at least the 5 years immediately preceding the date on which the minimum means of subsistence is awarded. I am about to. It considers that the sole point at issue is whether the Minimex may or should be refused in Mrs. Hooks' case merely because she lived in France for part of the 5 years preceding her application. According to the Arbeidsrechtsbank, the residence requirement laid down by Section 1 of the Royal Decree applies only to community nationals other than Belgians. So Belgian nationals didn't need to meet a requirement to have completed 5 years residence. Very similar to this case, in which British nationals don't need to show any economic connection to the United Kingdom, such as would give rise to a right of residence if they were not British nationals but were Latvian nationals. And we can see that the distinction between direct and indiscriminate and indirect is spelt out by the Advocate General 2 pages previously, 647. Under the heading paragraph 10 in the middle of that page, as the Commission has shown, if nationals of other community countries alone are required to have actually lived in Belgium for the 5 years immediately preceding the grant of the Minimex, that constitutes discrimination contrary to Article 7.2 of Regulation 1612/68 and to the prohibition of discrimination on grounds of nationality contained in Article 7 of the EEC Treaty itself. And then skipping out the next paragraph, he then deals with what would happen if Belgium changed the rule. It should also be noted that, as the Commission has pointed out, the imposition of the same requirement on Belgian nationals would not be enough to remove the discrimination. The Court has held that the principle of equality of treatment forbids not only direct and overt discrimination, as here, but also indirect and disguised forms of discrimination. Clearly, a residence requirement of the kind at issue here is, by its very nature, more difficult for a migrant worker to fulfil than for a national worker. So the difference between direct and indirect discrimination is that in the one case there was a test that was not required to be fulfilled by own nationals. That's direct. And in the other was a universal residence request suggested by the Advocate General as the possible replacement, which could equally be condemned, but on the different basis that it would be indirectly discriminatory.
So we've got the Advocate General in paragraph 10.
Yes.
Then, is that picked up anywhere in the judgment?
Well, in my submission, that's the possibility that the judgment does not consider what the position would be if the Belgians changed the rule. No. But in my submission, the language of paragraph 24 of the judgment, clear case of discrimination on the basis of nationality, shows that the Court agreed with the Advocate General and the Commission that a requirement of that a residence requirement that was not required to be satisfied by any step taken by national workers was direct discrimination.
Yes.
Now, in the respondent's case, it's said that the description of the distinction between direct and indirect discrimination in our case is a fair one. But nevertheless, the respondent seeks to argue that a requirement such as ours is not direct discrimination, with reliance on certain cases of the Court of Justice. So I just want to take your lordships to the key cases that the respondent relies upon, starting with a case brought by the Commission against Ireland, which is in volume 4, divider 51. Now, none of these cases were regarded as assisting the respondent by the commissioners or the Court of Appeal, and in my submission they don't assist the respondent on this issue either. I ask your Lordship's Divider 51 to turn to page 509 of the report to see the Irish laws that were in issue there.
500 and what?
509. About 2/3 of the way down, paragraph 14. Paragraph 14 sets out the text of the relevant laws. 2 orders being made by the Irish Minister for Fisheries, the first of which, entitled Sea Fisheries Conservation and Rational Exploitation Order 1977, was designed to prohibit the entry of sea fishing boats and fishing in a maritime area situated within that portion of the exclusive fishery limits of Ireland, and there's a geographical scope set out. And then in parallel there was a second order entitled Sea Fisheries Conservation and Rational Exploitation No. 2 Order, 1977, which exempted from that prohibition sea fishing boats not exceeding 33 metres in registered length or having an engine power not exceeding 1,100 brake horsepower.
Yes. One sees the point.
So sorry?
One sees the point.
Yes. Well, the point would appear to be that this is indirect discrimination at best. That would be my point, and has no application to a rule such as this, which is satisfied by virtue of nationality. Just take your Lordships to how the court dealt with it at 516. Paragraph 69. The Commission contends that although the Irish measures are based on apparently objective factors, that's the distinction, such as size and power of the boats, they are in fact discriminatory on 2 grounds. And as your Lordships will see from 70 to 71, in fact the Irish fishing fleet had small boats, whereas the Dutch and French fishing fleets had big boats. And the Court of Justice says, yes, it was discriminatory. We see that over the page at 79, 517. This certainly applies in the case of the criteria employed in the contested measures, the effect of which is to keep out of Irish waters a substantial proportion of the fishing fleets of other member states which have traditionally fished in those areas, whereas under the same measures no comparable obligation is imposed on Ireland's own nationals. But that, of course, was not because the rule said that the owner of the fishing boat had a right to reside in Ireland, for example. It was simply because of the size of the boats. So the French and Dutch could have fished in Irish waters if they'd chosen to use small boats. It's a classic example of indirect discrimination, possibly motivated by a directly discriminatory aim, but it's clearly indirect discrimination.
Well, as I read paragraph 46 of the respondent's case, they don't dispute that. Am I wrong about that? They say this was treated as a case of covert or indirect discrimination. See paragraph 79. So is there anything between you?
Well, there is, my lord, because the respondent is using the case of the Irish case to say, we see opening words of paragraph 46, that rules are indirectly discriminatory if they only bite on foreign nationals.
Where was that you're reading from?
I'm reading now from the respondent's case.
Yes, right.
Paragraph 46, the opening phrases.
Well, that's where they own it.
Now, that arises from the Court of Appeal's reasoning. If I could just ask your Lordships to look at the Court of Appeal's judgment on this point. The Court of Appeal's judgment appears in the appendix, and the relevant page is page 9. And I'll just take your Lordships through that reasoning. I think I've already anticipated some of it in my submissions. Paragraph 22. Mr. Cox focused his complaint of overt discrimination on the right to reside condition. As Lord Justice Moses says, I do not think he was correct to do so. Article 3 requires the conditions for entitlement to state pension credit under the legislation of the United Kingdom to be the same for Latvian nationals as for United Kingdom nationals. And he continues, accordingly, it is necessary to focus on those conditions as a whole rather than one particular element of those conditions to the exclusion of others. Now, I say that's wrong, and we've already seen in Hooks that an additional condition can be discriminatory regardless of the other conditions.
Lady Hill's already drawn attention to the peculiar use of the word accordingly at the beginning of some sentences, and that seems to be another one.
Well, the other point that I would make about this, my lord, is that, of course, the court does not consider all of the conditions for state pension credit, because that would include the condition of age and the condition of being of little means. Of course, if one wraps them into it, then ultimately the test can always be seen as indirectly discriminatory. But that is not the approach of the Court of Justice, and is not been the approach of the domestic courts to discrimination. If there is an additional hurdle that British citizens passed by virtue of their citizenship, but that others can only pass by virtue of some additional matter, as is here, in my submission, that is not the same conditions for those foreign nationals as it is for British citizens. So just continuing, Lord Justice Moses says the right to reside condition does not by itself entitle a claimant to the benefit. And that's a point repeated in the respondent's case. We don't understand that. It's not necessary for the condition to be a sufficient condition of entitlement. It's sufficient for it to be a necessary condition of entitlement. And there's then an exploration by Lord Justice Moses of the wider statutory provisions under domestic law of being in Great Britain. Well, one could equally point out, of course, that being in Great Britain, meeting the fullness of that statutory deeming test, does not entitle one to anything either. One must still be over 60 and have insufficient means. So there is no, in my submission, no rationale for stopping the consideration at the level of the sub-paragraph of a subsection of the statute. What one does is look at how the rule operates and whether it imposes a sine qua non, and this is a sine qua non. Continuing at paragraph 23, the only distinction drawn between nationals from member states other than the United Kingdom and the Republic of Ireland and nationals of the United Kingdom is in relation to the right to reside. Well, that's right, of course. All UK nationals satisfy that test. Well, that's right too. Other nationals who do fall within the provisions of Regulation 21A to E, who do not fall within the provisions of Regulation 21A to E, may do so, but with greater difficulty. Well, that's right, and it's the greater difficulty that is the directly discriminatory measure. And then the provision that I understand my own friend to be defending with the reference to the Irish case, I conclude that the conditions for entitlement to state pension credit are not overtly based upon the nationality of the claimant. The fact that nationals from other member states may qualify, whether as workers, members of the same family, or for other reasons, precludes such a conclusion. In other words, Lord Justice Moses understands overt to mean blanket. It's a discriminatory measure which excludes all foreign nationals. Well, we've seen in Hooks, of course, that it doesn't have to be blanket. After all, German nationals, Dutch nationals could have been resident in Belgium for 5 years, and then they would have met that requirement under Belgian law. So there's nothing in the case law of the Court of Justice to support the idea that overt means blanket. And there's nothing in the Irish case in my submission.
Before you put it away, he's got a fallback position in 25.
Yes, well, I'll return to the question of whether or not it can be indirectly discriminatory. The fallback position is that it's indirectly discriminatory, but that it's justified by reasons. The fallback position of the respondents is that it's indirectly discriminatory because it is, and Lord Justice Moses' reasoning seems to be it's indirectly discriminatory because some EU citizens can pass it. But because they find it harder to pass it, therefore it's merely indirectly discriminatory. Now I say that that's to misunderstand the case law, to misunderstand the correct approach to direct and indirect discrimination.
But I think in paragraph 25, the Lord Justice, rightly or wrongly, and you say wrongly, is still talking about direct discrimination.
Yes,
And here he moves to indirect in paragraph 26.
Exactly. That's what I was...
You're quite right.
This is not a point against you.
No.
I mean, it is quite an important point.
Well, I think it's a reiteration of what's been said in 24. Nationals from other member states may satisfy that test.
I'm just trying to see how, where the issue arises on Commission and Ireland. Looking back at the respondent's case in paragraph 45, the proposition is made is that the various conditions were considered cumulatively. Now, you would say that's not the correct approach, do you? Do you see that? Third line in paragraph 45.
Well, in 45 is quoting from Bressol, which I'll come back to in a moment.
It's
always going to be possible to accumulate conditions and then describe them as indirect.
Right.
But that doesn't get away from the fact that if a condition is a sine qua non, it's direct discrimination.
Yeah.
So if the right to reside were merely a factor, a relevant factor in some wider consideration, so, for example, if the test were that one must be residing here with a sufficient connection and a right to reside is an indicator of that connection, but not a sine qua non, that would be a good example of an indirectly discriminatory test. But when it's made a sine qua non, and it's a sine qua non which is satisfied by virtue of nationality, it's directly discriminatory. The example I gave in the printed case is that if one had a literacy test for the right to vote, as existed in some of the southern states in the United States, and one had prescribed by legislation that white people were deemed to be literate because they were white, but that black people actually had to sit down and do a literacy test. The fact that 90% of the black people passed the literacy test wouldn't make the discrimination indirect. It would still be direct, because only black people had to pass the test. Now, only Latvian citizens and other citizens who aren't British or Irish need to show the economic activity in the United Kingdom or the self-sufficiency in the United Kingdom in order to have a right to reside here. British citizens, Irish citizens, pass that test because they're British or Irish. If Miss Patmalniece were British, even if she'd lived the whole of her life in Riga, perhaps if we've managed to establish tomorrow that her father was a British seaman, she'd have a British passport and she'd pass the test immediately, despite being factually, in all other respects, in exactly the same position that she was in yesterday. That's the distinction. And the Irish case is nothing to do with that, because the Irish case is an example of a criterion that is independent of nationality on its face, but which, because of the factual, not the legal situation, the factual situation, operates to distinguish between Irish boats and other boats. There's nothing, one couldn't tell that from Irish law. One wouldn't have known from looking at the Irish law that Irish boats would be privileged. But one does know from looking at British law and Irish law that British and Irish citizens will always meet this requirement. Just turn to the other cases that are relied upon by the respondent in this regard, and turn to Bidar, which is... I'm so sorry, which is in volume 7 at divider 71. No, sorry, I'm so sorry. It's in volume 6 at divider 71. No, it's not. It's Martina Sala. No, I'm sorry, my lord.
It doesn't look right to me.
I'm afraid my note is wrong. Just bear with me for a second. Divider 77 in volume 7. Now, this is one of two cases that reliance is placed upon, the other being Bressol, where I say that the reason that the Court of Justice dealt with the case as one of indirect discrimination is because that's how the case was presented to the Court of Justice, and that's the issue that the Court of Justice was asked to deal with. In neither of these cases was the Court of Justice asked to deal with the question of direct discrimination.
But had they been, your argument is that they couldn't have failed to say it was direct.
No, my argument is, I mean, that would involve a consideration of the detailed law in each of these, one English and one Belgian. My submission is that they do not support the Secretary of State's proposition that one treats cumulative conditions as that one looks at cumulative conditions in the round, takes them all together, and then asks whether or not the result is indirectly discriminatory. My submission is that they simply dealt with the question of indirect discrimination because that's all they were asked to deal with. So in each of these cases, the Secretary of State says, oh, but if we were right, the court would have said this was direct discrimination. Well, the court simply wasn't asked that question in either of these cases. I can just take your lordships quickly to them to show why that's so. So, judgment in Bidar, this was a reference from the High Court, the Administrative Court in England and Wales. We can see in the opening part of the head note, the applicant, a French national who for more than 3 years before he began a university course in London had lived with his grandmother in and attended secondary school in the United Kingdom, applied for a loan for maintenance assistance during the course. He was refused on the ground that he did not fulfil the requirements so far as material to the case that he be settled in the United Kingdom in the meaning of the Immigration Act 1971, namely ordinary resident and not subject to any restriction on his length of stay. Now, the question that was referred is set out at page 816, or the questions at paragraph 6 of the Advocate General's opinion, and this is where, in this report, the questions appear. The Advocate General says the applicant challenged the decision refusing him a student loan for maintenance costs, claiming that the settlement requirement in the regulations constituted discrimination within the meaning of Article 12 of the treaty in conjunction with Article 18. The respondent contends that assistance with maintenance costs falls outside the scope of Article 12. And the questions then appear at the bottom of the page, and the first question is whether or not maintenance falls within the material scope. We don't need to look at the detail of that. Question 2, which begins 5 lines down, if either part of question 1 is answered in the negative, and if assistance with maintenance costs for students in the forms of grants or loans does now fall within the scope of Article 12, what criteria should the National Court apply in determining whether the conditions governing eligibility for such assistance are based on objectively justifiable considerations not dependent of nationality? So the court was referring a question about the application of the indirect discrimination rule that we've just been looking at. The possibility of justification grounds of considerations independent of nationality. And the court deals with question 2 at page 844 of the report. And the court says at paragraph 50, for this purpose it should be first examined whether the legislation at issue in the main proceedings distinguishes on the ground of nationality between students who apply for such assistance, and then recites the phrase that I've already taken your lordships to, 51. It must be recalled here that the principle of equal treatment prohibits not only overt discrimination based on nationality, but also all covert forms of discrimination which, by applying other distinguishing criteria, lead in fact to the same results. And then in paragraph 52 it sets out the relevant domestic conditions, and at 53 such requirements risk placing at a disadvantage primarily nationals of other member states. Both the condition requiring an applicant for that assistance to be settled in the United Kingdom and that requiring him to have resided there prior to his studies are likely to be more easily satisfied by United Kingdom nationals. And at paragraph 63, having looked at whether or not it can be justified, the court goes beyond, decides to answer the question, as it were, on the facts. Paragraph 63, the answer to question 2 must accordingly be that the first paragraph of Article 12 EC must be interpreted as precluding national legislation which grants students the right to assistance covering their maintenance costs only if they are settled in the host member state, while precluding a national of another member state from obtaining the status of settled person as a student, even if that national is lawfully resident and has received a substantial part of his secondary education in the host member state and has consequently established a genuine link with the society of that state. Now, nowhere in my submission...
Did English students qualify as of right?
No. English students needed to be settled, so they needed to be ordinarily resident, and they needed to have been ordinarily resident for 3 years.
I think paragraphs 17 and 18 on page 840 give the
Yes.
is the court's account of the national legislation.
And we see at 16, just above, that there was an exception for workers.
Yes.
So the court wasn't asked, is this direct or indirect discrimination? The court was asked on the presumption that this is the kind of discrimination that could be justified. Is it? And the answer is no.
But again, I mean, it may not matter, but I just ask, I mean, would it be your submission that had it been approached on the basis of direct, it would have been direct?
I think there is an argument here that this would have been direct discrimination, yes. Because British citizens, because of the requirements to be settled, included a requirement to be lawfully present in the United Kingdom, and a British citizen automatically meets that requirement. And because under paragraph 18, at least if the court were right in its holding, that a person could not, in his capacity as a student, attain the status of being settled. And that didn't mean a student couldn't be settled, it just meant that by being a student, one couldn't become settled. So it might have been capable of being argued as a case of direct discrimination. The court wasn't asked to look at it like that, and in the end it didn't matter, because the court held that the rule was unjustified discrimination. So in the end, Mr. Bedar won. But in my submission, this case doesn't help us find support for the Secretary of State's argument that when the court has considered indirect discrimination as including cases where there is a sine qua non as part of a series of conditions of entitlement, and a sine qua non which is met by virtue of British citizenship. Can I just ask your Lordships to go to the case of Bressol, which is in volume 4. And that divider 48. And this case postdates the Court of Appeal's judgment. And it concerns a set of Belgian rules relating to access to Belgian colleges. And if I could show your Lordships how the case was put to the Court of Justice, which we get from the Advocate General's opinion at page 575. At paragraph 40 of her opinion, she says, is this difference in treatment direct or indirect discrimination based on nationality? And at 41, in its letter of formal notice, the Commission took the view, and I should add, just pausing there, that was a separate proceedings in which the Commission brought infringement proceedings against Belgium. The Commission took the view that because Belgian nationals merely have to establish their residence in Belgium to satisfy the condition in the first paragraph of Article 1 of the decree, while all others have to satisfy an additional condition, the discrimination is direct. The Commission did not pursue this line of argument in the present proceedings, contenting itself, as did all other parties, with examining the questions referred on the basis of indirect discrimination. So pausing there, at the oral hearing before the Court of Justice, none of the parties, including those seeking to defend the decision, addressed the matter on the basis of it being direct discrimination. All of the oral submissions of the parties were that it was indirect discrimination. The Advocate General, however, says, I do not believe that the court can or should avoid the issue. And she then goes on to explain why, in her opinion, the matter may be classified as direct discrimination. And first of all, she deals with the distinction between direct and indirect discrimination, paragraph 43. And she there sets out some reasoning which I say supports the submissions that we've made about the distinction between direct and indirect. And if, in particular, can I just ask your Lordships to look at paragraph 49? And essentially, it's a critique of the use of the words overt and covert instead of the words direct and indirect. And she says in paragraph 50, I must confess I do not find it helpful to draw the distinction in this manner. It is quite clear that the distinction between overt and covert discrimination does not necessarily always coincide with that between direct and indirect discrimination.
This is Eleanor Sharpston, isn't it?
This is Eleanor Sharpston, yes. In my submission, that's true on a linguistic basis, but one ought to understand the court's references to overt and covert as being to direct and indirect, and that isn't a proposition that's disputed in the respondent's case. So she then gives us an example, 51, an example of covert, direct discrimination, which is where Ms. Decker was refused a job because she was pregnant. And
On the basis that only women can get pregnant.
on the basis that only women can get pregnant, yes.
And James and Eastleigh Borough Council will be a similar example.
Yes. And we say James and Eastleigh Borough Council is an example that it doesn't matter that James and Eastleigh Borough Council is, and we have it in the authorities, is the case where the free access to the swimming pool is available to those of pensionable age, but at a time when pensionable age differentiated between men and women, it was therefore a proxy, or one sees through it to see that it's discrimination between men and women, even though if one reads it and one doesn't know, it's not.
Yes, exactly. But of course, all women reach pensionable age at a particular time. All men reach pensionable age at a particular time.
Yes.
All men cannot become pregnant. Most women can.
Yes.
So
But also some men are of pensionable age. And even though some men were of pensionable age, it was still held to be
but
direct
at a particular
discrimination.
age concerned.
Yes, but even though many men would satisfy the requirement for free swimming, it was still direct discrimination because they did not satisfy it on the same conditions as women. I can take your Lordships to that if you wish. But
I think in Eastleigh, the Court of Appeal did decide it was indirect discrimination, although it's probably not going to help us very much, but it's an interesting case because it may be the Borough Council were acting from the best of motives. I don't think by fixing the special terms for free swimming, they were intending to get some extra money. They probably thought it was right to set it at 60 for women and 65 for men.
yes, and in fact their justification was that they were linking it to retirement age and not to anything based upon sex. I can perhaps take your Lordships. I think it's been raised, so I'll turn to it in a moment.
Sorry, I do not wish to put you off your course
No,
at all.
you're not.
We need to complete Bressel.
We'll finish with Bressel.
Well,
If we
we've got
just
to paragraph 50.
yes, if we just go to 55, where I think we
Where are you going to?
I think 55 over the page.
Well, 53 is quoted by the respondent in his case, or her
Yes.
case.
I would rely upon 53, particularly the closing words, based on a criterion which is either explicitly that of nationality or necessarily linked to a characteristic indissociable from nationality.
Yes.
Now, this criterion is not expressly textually linked to nationality, but it might as well say British or Irish citizens qualify and other persons must show a right to reside in the United Kingdom, because British and Irish citizens qualify for that condition by virtue of their nationality. But we've already seen the cases that a provision isn't deprived of its directly discriminatory characteristics by the fact that some people in the discriminated against class can meet it. At 55, this analysis implies crucially that for there to be direct discrimination, it is sufficient that at some point in the chain of causation, the adverse treatment received by the victim is grounded upon or caused by using a characteristic that may not serve to draw distinctions to distinguish that person from others. I shall refer to this process for convenience as a prohibited classification. A general definition can be formulated on this basis that, so far as I can see, accurately reflects all situations recognised by the court as constituting direct discrimination on any ground prohibited by community law. I take there to be direct discrimination where the category of those receiving a certain advantage and the category of those suffering a correlative disadvantage coincide exactly with the respective categories of persons distinguished only by applying a prohibited classification.
That's my point, distinguished only.
But in my submission, what the Advocate General isn't there doing is ruling out an analysis of direct discrimination where there are exceptions for the victim class. So if there have been exceptions for the class of DECA for pregnant women who'd previously been employed by the company, that wouldn't have made the discrimination against Ms. DECA any less direct because it was founded on her pregnancy. Now, the court takes up part of the Advocate General's suggestion, the linguistic, textual part, but it doesn't, in my submission, understandably, deal with the question of direct discrimination, which after all had not been the subject of any submissions by the parties. And we see the court's consideration at page 603. Paragraph 40, under the heading, the existence of unequal treatment, it should be recalled that the principle of non-discrimination prohibits not only direct discrimination on grounds of nationality, but also all indirect forms of discrimination, which by the application of other criteria of differentiation lead in fact to the same result. So the court frames it by saying we're going to talk about indirect discrimination, and then sets out the familiar test. Unless objectively justified and proportionate to the aim pursued, a provision of national law must be regarded as indirectly discriminatory if it's intrinsically liable to affect nationals of other member states more than nationals of the host state, and there is a consequent risk that it will place the former at a particular disadvantage. And then analyses the cases on the basis of indirect discrimination. So it's now using indirect and direct rather than covert and overt as language, but it hasn't taken up the Advocate General's proposal to deal with an issue that hadn't been argued. So in my submission, it's of no assistance to the respondent for him to say, but look, if on the Advocate General's analysis and the appellant's analysis, this was really direct discrimination, and by not dealing with it, the court is rejecting that analysis. The court isn't rejecting that analysis. The court is addressing the case that was put to it and the debate that was put to it.
Which bit of the case was this all done? I'm lost.
I'm so sorry.
Which bit of the case?
I was looking at page 603 at paragraph
Yes,
40.
Yes, and which bit are they there discussing? I mean, which bit of the discrimination? What is the discrimination they're discussing?
Well, the discrimination that they discuss goes on to be set out at 42 to 43. So we see in 42, unrestricted access to the medical and paramedical courses covered by that decree is available only to resident students, that is those who satisfy both the requirement that their principal residence be in Belgium and one of the 8 other alternative conditions listed in points 1 to 8.
First of which is that the person has the right to remain permanently in Belgium.
The first possibility, yes, the first of the 8 alternative possible ways to satisfy the second condition, yes.
And we see the questions at page 601. We're looking at first and second questions in this part of the judgment.
We're looking at the part of the answer as to whether or not there is unjustified indirect discrimination. We see the 8 alternative conditions are at page 570, paragraph 12. And those are alternatives.
A Belgian national has the right to remain permanently in Belgium without more ado.
Yes.
So, I mean, on your submission, that it's just an open and shut case on that basis.
Yes, and that's how the Advocate General
That's how she
viewed
did.
it.
That's paragraph 128 or something.
Which paragraph of her?
128, I think.
128.
Yes, at 128. Page 591.
Indicated
Well, she deals with it as direct.
Direct.
She explains why she thinks it's direct at paragraph 64, which is at page 579. And then she explains,
Yes, exactly.
addresses whether or not it can be justified at 128.
Exactly.
The second cumulative condition. And the first paragraph.
And that's because all Belgian nationals automatically meet the first requirement and therefore didn't need to qualify under any of the others, whereas non-Belgian EU citizens would need to meet one of those requirements by doing something more than being Belgian nationals.
But it is very interesting that the court doesn't take up the Advocate General's direct challenge, saying this is direct discrimination, and proceeds to discuss the potential justifications for this discrimination at great length. That's a very significant thing.
Well, my lady, your ladyship, I see what your ladyship says, and it would seem to be, in that sense, unfortunate that none of the parties have made submissions in relation to direct discrimination, and the court did not appear to be being presented with a case by any of the parties that direct discrimination was an issue. But in my submission, it would
Maybe
be...
that's a rather Anglo-centric view of the proceedings.
Well, in my submission, it wouldn't be, because in my submission, the Court of Justice is like this court, bound to adopt a fair procedure. And if none of the parties before the Court of Justice had had an opportunity to develop their submissions on direct discrimination, then the court could, I accept, have reopened the oral proceedings. The court could have said, this is a very interesting issue raised by the Advocate General, we want to hear what the parties say about it. We're going to call them back and give them an opportunity.
So why would it be interesting, as opposed to, in your view, obvious?
Well, in my submission, I say it would be obvious, and in my submission, the Advocate General's opinion supports that view. But the court, we don't know why the court decided not to reopen the oral procedure, and we don't know why the parties put their cases as they did.
I mean, there is some categoric rule in Luxembourg is that if it's direct, end of story.
Well, that's explored in the Advocate General's opinion.
Well, I noticed that she said...
Paragraph 128.
Exactly, but I mean, it may be that, you know, where that's not so, that therefore it's you know, if it's borderline, it may be that it's right to treat it as indirect, and you see if you can justify it. I don't know. I mean, I just asked.
Well, my lord, these are the cases that we have, and this is the closest where the court gets asked, within its own internal procedures, a direct question about the distinction between direct and indirect. And you see what the court has done with it, and you have my submissions on the background as to how that's come about.
But I mean, is there any case where the court said, well, this is direct, end of story?
Well, I say that Herx is such a case, yes. In Herx, the court said this is a clear case of discrimination on nationality grounds. End of story.
So could you just show us that again? So
Yeah.
Yes, of course. It's in volume... I hesitate. So, volume 5, divided 64.
Yeah.
Now, this was the a requirement in paragraph 6, page 649, paragraph 5.
They've got to have lived
Actually resided in Belgium for at least the 5 years immediately preceding the date on which the minimum means of subsistence is awarded. And that was a condition that did not apply to Belgian nationals. And the court says of that at paragraph 24, page 653.
Okay, so discrimination.
clear case of discrimination on the basis of the nationality of workers.
Yes.
Consequently, it must be stated in answer to question 3 that a social benefit guaranteeing a minimum means of subsistence in a general manner constitutes a social advantage within the meaning of Regulation 1612/68. Article 7.2 of that regulation must be interpreted as meaning that the grant of such a social advantage may not be made subject to the requirement that the claimant should have actually resided within the territory of a member state for a prescribed period where that requirement is not imposed on nationals of that member state.
And is any attempt, I've forgotten, been made to justify this?
Questions don't seem to raise that today. I mean, they go on to different points. If you look at question 3 and 4.
My Lords, I can't see anywhere in the report, I'll look at it more carefully in a moment, I can't see anywhere in the report that that the court deals expressly with the idea of justification, no.
I mean, it's odd. I mean, if you see these cases and people are missing the point according to you all the time.
Well, not here. In my submission, they're not missing the point here. This is direct discrimination and therefore the court holds that it's incapable of justification.
Well, yeah, okay, but in this...
Well, they don't say it's incapable, they just don't, they don't turn to any suggested justification. I mean, you know, it just seems to be astonishing, given the amount of Luxembourg law there is, that nobody's ever actually said anything one way or the other.
Well, my Lords, I can't really dissent from that because that's the tenor of what Advocate General Sharpston says in her opinion in Bressol, that
It couldn't be more clearly put. Paragraphs 128 to 131, she's really making her point as forcefully as she possibly can, and it just seems to be overlooked by the court when it comes to deal with this judgment. You see 128 at page 591.
We rely upon the fact that the court has never held that direct discrimination can be justified, but we can't rely upon a holding of the court that and a clear and unambiguous holding that direct discrimination cannot be justified, except for 2 cases that I just want to show you, Your Lordships, where it may be said that those aren't clear enough. But given the time, I wonder if this would be a convenient moment.
Well, we're slightly early. So just a few minutes.
No, I'll
Is
go
there
on. Yes,
something we can
absolutely.
use up?
If Your Lordships will look at Martinez-Sala,
Yes.
which is in volume 6 at Divider 71.
Divider 67, did you say?
Volume 6
Yes,
at Divider 71.
71.
Martinez-Sala.
I see it's the subject of footnote 97 in the one we were just looking at in Eleanor Sharpston's opinion.
Yes.
Oh, yes. Yes. Yes, she refers to it in footnote 97 of her judgment, page 591.
Can I just ask your Lordships to look at the questions that were asked in that case, which is at page 2715 of the report.
Yeah.
So the first question was about the personal scope of Regulation 1612/68 and Regulation 1408/71. Was a Spanish national living in Germany, and then there's a description of her circumstances. 4 lines, I'm so sorry, I'm looking at the very bottom of page 2715, the indented paragraph 1. First question, was a Spanish national living in Germany who with various interruptions was employed until 1986, and then skipping out 2 lines, still in 1993, a worker within the meaning of Article 7.2 of Regulation number 1612/68, or an employed person within the meaning of Article 2 in conjunction with Article 1 of Regulation 1408/71. So about a personal scope of the 2 prohibitions on discrimination that we've been looking at, the one that relates to workers in the narrow sense and the one that relates to workers in the wider sense. The second question was, is the child raising allowance within the material scope of Regulation 1408/71? Third question, is it within the material scope of 1612/68? And then lastly, a general question, is it compatible with the law of the European Union for the German law to require possession of a formal residence permit for the grant of child raising allowance even though they are to nationals of a member state, even though they are permitted to reside in Germany. And the court answers the first two questions by, first question by reiterating its case law on those provisions and referring the national court to them. It answers questions 2 and 3 by holding that the benefit in question is indeed within the material scope. And then it deals with the residual question, and this is why this judgment is important. It begins with that at page 2722. Now that we've gone to this judgment, I'll mention some other passages that are going to be relevant to the other submissions I'll make this afternoon. So paragraph 46 at the bottom of 2722, by its fourth question, the referring court seeks to ascertain whether community law precludes a member state from requiring nationals of other member states to produce a formal residence permit in order to receive a child raising allowance. Now, pausing there, this question only arises, of course, if the appellant wasn't able to benefit from the prohibitions on discrimination in respect of Regulation 140871 and Regulation 161268. If she were within the personal scope of those, on the matters referred back to the National Court, she would qualify under those provisions.
Well, shall we come back and look at this after the short adjournment? 2 o'clock then.